Well, welcome everybody to our webinar on issues relating to off-hire. Henry and I are going to cover the topics on the slide in front of you. You'll see we're going to be talking about standard and specific off-hire clauses, whether those clauses are period or net time of loss clauses. We're going to be discussing what constitutes prevention of the full working of the vessel and what circumstances the vessel will be off-hire. Can a vessel be off-hire as a result of a breach by charterers? What is the effect of the vessel being off-hire? And also, are damages available? And there will also be a chance to discuss equitable set-off. Now, the starting point under any discussion on off-hire is that under a time charter, the charterers must pay hire to the owners for their use of the ship. Now, an off-hire clause may, however, allow charterers to suspend payment of hire for the duration of any delay caused by certain triggering events which prevents the ship from performing its charter service. Now, most time charter parties, in fact, contain off-hire clauses, and they will vary according to the particular circumstances of the hire. Now, taking this into account, this starting point, the general principles the following two general principles apply to off-hire clauses. Firstly, the burden is on charterers to show that any off-hire clause applies in the circumstances. If there's any doubt as to what the words mean in an off-hire clause, then those words must be read in favour of the owners, because the charterers are attempting to cut down the owner's fundamental right to hire. Now, secondly, an off-hire clause operates independently of any breach of contract by the owners. An off-hire event may not even be a breach of contract, as the judge in the case of the Joanna noted. So a breach of contract claim would result in a claim for damages, subject to usual proofs of loss and remoteness and mitigation, which you compare with the operation of an off-hire clause, which results in the suspension of hire, subject to charterers proving that a certain triggering event has occurred and there's been a loss of time. And Henry will look at this in a little more detail later. So what are off-hire clauses? Well, at the time of fixing, the owners and charterers are able to agree between themselves the conditions under which the vessel can be placed off hire. So the circumstances in which a vessel will be off hire and the duration of any off hire period will vary from fixture to fixture. Now, saying that, off hire clauses can generally be categorized either as standard clauses, ones that almost always appear in the standard form contracts, or a specific type of clause that may be added as an additional rider clause. Now, the New York Produce Exchange Form, the NYPE, is the most widely used standard time charter in the dry cargo sector. And Clause 15, the standard off-hire clause, is set out here. Now, you'll see it's quite a long clause, and there are various aspects of an event or incident that need to be considered to prove that the vessel is off-hire, in particular the type of event, and in this case, whether there has been a loss of time. These points have been underlined, and we will look at these in a little more detail later. Now, specific off-hire clauses, they deal with particular types of event, and I've set out here a couple of examples. The first one is capture, seizure, and arrest. Should the vessel be captured or seized or detained or arrested by any authority, the payment of hire shall be suspended until the time of her release. The Global Santos, which I've mentioned there, is a case that involves a dispute as to off-hire under such a clause, and we'll come on to look at this a little bit later. Sorry, I'll just go back on the slides a little bit. I've gone forward. You'll see that the rejection of a vessel's holds may also be an event that puts the ship off hire. If the holds are not clean and dry and are not ready as required, this particular clause stipulates that the ship is placed off hire from the moment of rejection until the time that the holds are fully passed. Another situation where the hire of a ship is or may be suspended is an instance of deviation from the course of the voyage. Now, this is a good example of a clause which specifies that the period for off-hire is from the point when the vessel actually deviates from the course of the voyage, and hire only resumes from a point specified when the vessel is actually again efficient or in an equivalent position. Now, under most off-hire clauses, a ship will only be off-hire if there has been some loss of time, but it's worth looking at the wording in each case. You'll see, for example, that the seizure and arrest provision that we looked at before didn't actually mention loss of time. And the intention behind the wording in these sort of clauses is that charterers should not be permitted to earn a windfall profit by taking advantage of an event which does not in fact cause them any overall loss of time. So off-hire clauses typically fall into one of two types. First, there are the so-called period clauses. These are used to refer to, sorry, I'm just going to go back one slide here. Period clauses. These are used to refer to a period of time during which the ship is prevented from working. And secondly, there are also net loss of time clauses, and these are used to refer to the period of time by which the progress of the charter service has been delayed. So in other words, what loss of time has occurred. Now, period clauses, they usually establish a clear-cut period of off-hire. So the ship goes off-hire when the full working of the ship is first prevented and comes back on hire as soon as the full working recommences. So you will see, for example, the period off-hire clause in Hogarth and Miller on the screen there, which read, in the event of loss of time from deficiency of men, the payment of hire shall cease until she be again in an efficient state to resume her service. And this is a good example of a period off-hire clause. Similarly, in the Bridgestone Maru number 3, the court held that the off-hire clause in the Shell Time 3 form was a period clause and not a net loss of time clause. The relevant words in that clause making it a period clause were the fact that it was said to be, or hire was said to cease to be due from the commencement of such loss of time until, despite the reference there to loss of time. This is because it defined a clear beginning and end point during which hire was not payable. So, I mean, it's been said that the courts prefer to construe off-hire clauses as period clauses if they can, as it makes any calculations easier. There is a beginning and an end point. However, the commercial world seems to prefer these net loss of time clauses in order to avoid any windfall events for charterers where there may not have been an actual loss of time. So net loss of time clauses are used to refer to the period of time by which the progress of the charter service has been delayed. In other words, there has to be some calculation of the delay or loss to the progress of the adventure. And such clauses allow deductions equivalent to time lost rather than for a whole defined period. And the NYPE wordings are a net loss of hire clause that you will recall from the earlier slide that refers to for the time thereby lost, and that is, as said, a net loss of time. Similarly, clause 11A of the Bull Time Form 1939 is a net loss of time clause because of the word use of the word no hire shall be paid in respect of any time lost thereby. And that position is further clarified by the use of the additional words during the period in which the vessel is unable to perform the service immediately required. And that makes it clear that full hire becomes payable as soon as full efficiency is resumed. Now, Henry is going to now discuss what is meant by the words full working of the vessel.
Thank you. Okay, so having looked at different types of off-hire clauses, we now turn to the key elements that are required for a ship to be placed off-hire. Under the NYPE form, the charterers must establish all three of the following in order to put the ship off-hire. Firstly, the full working order of the ship must have been prevented. Secondly, it must have been prevented by one of the causes or risks listed in the clause, which Pamela will go on to discuss in a moment. And thirdly, there must have been a loss of time to the charterers. Now, Pamela's just discussed loss of time, so I'll now go on to discuss the fundamental question of whether the full working order of the vessel has been prevented. And this is the first question to consider in every potential off-hire situation, as the leading off-hire cases, such as the Aqua Charm and the Laconian Confidence, have set out in very clear terms. So this really is your starting point. But the problem is, when you actually look at the words, the expression preventing the full working order of the ship can be rather ambiguous. Do the words refer, for example, to the mechanical efficiency of the ship or the ability of the charterers to use the vessel to fulfill their commercial objectives? So we have to turn to reported case law for guidance on what the words actually mean. And it's now well established that the full working order of the vessel is prevented when she can't perform the next operation that charterers require. For example, if the next operation that the ship needs to perform is to sail to the discharge port, but she's unable to do so, then the ship is being prevented from working. If, on the other hand, the ship's unable to sail, but the next operation required of her is to remain at berth and discharge, then the full working of the ship hasn't been prevented. And you often see exactly that situation when ships are under arrest. Depending on where the arrest is, whilst they can't sail, they may well be permitted to carry out cargo operations. Now, it's important to draw a distinction between what the charterers wish or hope or expect the next operation to be, and the next operation that the performance of the charterer's orders actually makes necessary. And let's consider the following example. A vessel is chartered on the NYPE 46 standard form with no amendments to the off-hire provisions at clause 15 to load a bulk cargo. During loading, the vessel's main engine suffers damage so that she can't sail at the warranted charter speed. But the vessel's ability to load cargo remains unaffected. And as this is the service which the charterers require at the time the damage is sustained, the vessel's ability to deliver that service is unaffected. The charterers therefore cannot place the vessel off hire. And the fact that she can't perform some other hypothetical or future service is irrelevant. Now, the leading case on this is the Bergsund, and its facts are a really useful illustration of the principle in question. And let me give you those facts, and then let's have a poll to see whether you think the full working order of the vessel was prevented. The off-hire clause in that time charter included the words, quotes, or any other cause preventing the efficient working of the vessel. And after carrying a contaminated cargo of butane, the crew cleaned the ship's tanks on the ballast voyage, and although the crew weren't negligent, their efforts proved inadequate, and time was spent in further extensive cleaning at the load port, which in turn delayed the performance of charterers' orders to load. So the question for you is, in circumstances where loading was delayed due to the ship's tanks being dirty, do you think the full working of the vessel was prevented? Yes or no? Now, whilst you're considering that, I will say just one thing. You've all got a get out of jail free card essentially here, because ultimately, whilst the High Court and the arbitrators came to one conclusion, the matter was unclear enough for the Court of Appeal to have to determine this once more, and it took a different view. Okay, right. Thank you. Here's the answer. The arbitrators and the High Court held that the ship was off-hire during this further cleaning, as she wasn't in an efficient state to provide the service required, namely to load the next cargo. But the Court of Appeal disagreed, and it concluded that the service required was not the loading of the cargo, but further cleaning. And I'll just read out to you exactly what the Court of Appeal said. The critical question is, what was the service required of the vessel on the date in question? What were the charterer's orders? They were not to load the cargo. That was the last thing that charterers would have ordered, since the vessel's tanks were unclean. The orders were to carry out further cleaning. That was the service required, and the vessel was fully fit to carry it out. So in summary, if because of an unexpected event, the service needed by the charterers changes, then it's the service the charterers actually need as a result of that event which is relevant, not the service which they originally hoped to obtain. Next slide, please. Okay, now let's turn to some issues which can arise in terms of whether the service has been prevented. The first question to consider is whether the full working of the vessel is prevented simply because the operation in question has become more difficult or more time-consuming. And let's take an example in a reported case, the Morava AS. And in that case, the ship was chartered on the NYP form and carried grain from the US Gulf to Algiers. But the cargo was wet damaged because of defective hatch covers. And because of the damage, discharge at Algiers took 15 days longer than it otherwise would have done. But at all times, the ship was fully capable of performing every service required of her, and in particular, fully capable of discharging cargo from her holds, but just more slowly. And the court held that the ship was therefore not prevented from working, and so was not off-hire. What about obstacles? Is a ship prevented from full working order because it encounters an obstacle and is unable to proceed because of some physical impediment, such as shallow water or sandbar? Well, the general position is that external factors won't prevent a ship from being in full working order. But there's a very important exception to that general position, which is where the external factor is directed at or relates to that specific ship. And let's consider a couple of examples to illustrate this. First example, a ship can't navigate due to scuttled ships blocking a river during wartime. Now that was exactly the scenario during the Second World War in a case called the Errington Court. And the court held that as the blockade affected all ships, it didn't prevent the full working of the vessel, even though it was actually enough to frustrate the entire charter party. By contrast, a second example is where a ship is detained by pirates. As that's specific to the ship in question, it was held in a case called the Saldanha that it did indeed prevent the full working of the vessel. And finally, let's consider what happens when a ship undergoes repairs. Well, in short, if the repairs are outside the ordinary activities to be expected of the vessel during the charter period, the ship's likely to be prevented from full working order. And a good example of that arose in a case called the Clipper São Luís. The ship was delayed for a number of weeks dealing with a fire caused by a cigarette which was discarded by a stevedore into the ship's holds. And the court held that it was wholly unreal for owners to argue, as they tried to, that the vessel was simply performing the service required of her by remaining at the quayside fighting the fire. Pamela.
We're going to come and look now specifically at events that cause interruptions to the charter service and how charter parties have evolved to cover certain events. So the next series of slides will show how the various versions of the NYP forms have been revised over the years. Now, under the NYP 1946 form, in order to claim the benefit of an off-hire clause, the charterers must also prove the full working of the ship has been prevented by one of the causes or risks listed in the clause. Now, these are set out on the slide there for you. Fire, grounding, and dry docking are largely self-explanatory, and it's unlikely that there will be any debate as to whether the vessel was on fire or had run aground or was in dry dock. So typically, disputes arise on the other listed causes, which we will look at in a moment. Now, it's also worth noting, although it's not on the slide here, that under the NYPE form, there's a provision for a deduction from hire covering time lost, extra fuel consumed, and all extra expenses arising from a reduction of the ship's speed on a voyage by reason of a defect in or breakdown of any part of the hull, machinery, and equipment, and that's quite a useful provision to bear in mind. Now, further revisions have been made to the various NYPE clauses. We'll come to look at the 2015 form in a moment, but under the 1993 form, it's interesting that further revisions were made that give rise to off-hire periods. So in addition to those in the NYPE 1946 form, the following causes, which are contained in clause 17, are also worth bearing in mind. You'll see that what was simply deficiency of men has now become deficiency and or default and or strike of officers or crew. Detention by arrest of the vessel has been added, unless such arrest is caused by events for which charterers, their servants, agents or subcontractors are responsible. There's also a revision for detention by average accidents to the vessel or cargo. And the mop-up clause has been slightly amended. So instead of saying by any other cause preventing the full working of the vessel, it now says any other similar clause. We'll come to look on at those in a moment. So there were further revisions in the 2015 form, and you can see that I've underlined a few of the provisions there where there have been particular changes, and you'll see that in particular it now covers events where there are deficiencies discovered as a result of inspections by port state authorities leading to a detention of the ship, and it also includes events for which subcharterers of the charterers are responsible, as the ship may be operating under a sub-time charter or voyage charters during the time charter period. So looking at the detail of the causes or risks and how they are interpreted, Clause 15, as we saw, of the Standard M 1946 form refers to a deficiency of men only. However, the 1993 form replaced the word or added to the word deficiency with deficiency of men and or default and or strike of officers or crew. So what is the distinction between the two? Well, deficiency of men does not apply to a situation in which there is on board a full complement of officers and men able to work, but some or all of them refuse to do so. There needs to be an actual deficiency in numbers, and you'll see the reference there to the Ilissos. Case law is slightly unclear as to whether there is a deficiency of men, whether the full crew complement is on board, but some of the crew are incapable of working due to illness or injury, which is obviously something of a topical issue at the moment. Now, default of men only applies if the ship's crew refuse to perform their duties or deliberately withhold their services, and that therefore covers the gap created where it was only a deficiency of numbers that qualified as an off-hire event. Now, moving on to breakdown or damages to hull and machinery. In terms of breakdown, this is generally construed in its ordinary and reasonable sense. In other words, when the condition of the hull or machinery becomes such that it's necessary to interrupt the service to charterers. For example, if there is a breakdown in the main engine because a part needs replacing or has broken and the engine has to stop for a couple of hours while that's done. The actual technical meaning of breakdown was considered by the Court of Appeal in a case, the Alpha Pearl, which is cited there. But that actually concerned the breakdown of a discharge pipe at a shore facility. And Lord Justice Clark in that case stated that, as I see it, a breakdown of equipment, such as a discharge pipe, occurs when it no longer functions as a pipe. So in other words, he drew a distinction between the actual breakdown and its cause. Now, moving on to detention by average accidents to ship or cargo. An average accident means an accident which causes damage to the cargo and not by the cargo. The word average here is assumed to originate from the language of insurance, where average actually means damage. Now, some care needs to be taken when considering damage and how that damage arose, and it's useful to illustrate that, I think, with a couple of examples. So, inevitable damage to cargo will not fall within the exception. As an example, a vessel is chartered on an NYP 1946 form with no amendments to clause 15, chartered to carry a consignment of pistachios from Syria to France. Pistachios are loaded moist, and as a result, the cargo itself heats and becomes damaged. The vessel is not off hire for the time spent discharging the cargo because the damage was not accidental. Cargo's condition prior to loading made it inevitable that some damage would be found during discharge. Now compare that with damage caused by an accident which will fall within an exception. Another vessel chartered on the same NYP 1946 form with no amendments, this time to carry steel from South Korea to the US. During loading, the wire on one of the vessel's cranes snaps, sending steel bars plunging into the hold onto a stow of steel coils. 8 hours are lost while the damaged cargo is removed from the hold and the balance restowed. Now, because the crane's lifting wire broke accidentally, absent any other cause in the charter to the contrary, the vessel is off hire for this particular period. Case law suggests that minor damage may fall outside the scope of detention by average accidents. The arbitrators in the case of the Laconian Confidence held that an average accident to cargo required an event that was probably of some magnitude, a view which was then accepted by the court on hearing the appeal from the award. So once both the accident and damage have been established, then the next question to ask is, has the average accident given rise to any detention of the vessel? Now, detention in this instance means something more than mere delay. It would need to be some physical or geographical constraint upon the vessel's movements in relation to her service under the contract. We're going to look at events for which the charter is responsible. And I've put on here the case of the Global Santosh, which is quite a useful illustration. Now, that case involved a chain of charter parties. Now, Cargill had time chartered the vessel for one time charter trip from the owner's NYK. The vessel was then subchartered. On its arrival at the discharge port, there was a delay at Anchorage in Nigeria of about 2 months before the vessel could proceed to discharge its cargo of bulk cement. Subcharters then arrested the cargo to secure unpaid demurrage because of the delay from the receivers, and by mistake, the order of the Nigerian court also included an arrest of the vessel. Now, time charterers Cargill withheld hire from NYK for the period of that arrest. Now, NYK owners argued that the vessel was not off hire, as the key point, they said, was that the subcharterer who arrested the vessel was to be considered an agent of cargo. an agent of an agent of Cargill, and you will see the proviso in italics on the slide there. Now, the arbitrators held that neither the subcharterers nor the receivers were acting as an agent for the purpose of carrying out obligations of the Charter of Cargill under the time charter party, and that Cargill were therefore entitled to place the vessel off hire according to the terms of that charter. Now, the High Court overturned this and held that the word agents in the off-hire clause was not used in the strict legal sense, and it actually included parties to whom obligations of the charterers under the charter were delegated. And the Court of Appeal also subsequently considered that potentially both the acts of the receivers and subcharterers could have occasioned the detention of the vessel. So, in other words, they gave the wording of the clause a very wide and expansive view of who was an agent in this scenario, and they held that the vessel remained on hire. The case went to the Supreme Court, who reversed the High Court and the Court of Appeal and restored the tribunal's initial decision. The proviso that you can see in italics in the off-hire clause did not apply, and the vessel was off-hire during the period of arrest. Now, this was because in no sense could the party carrying out the arrest be said to have done so on behalf of the time charter of the vessel. As such, the arresting subcharterer could not be considered as Cargill's agents for the purpose of the off-hire clause. So the key point here is to take away is to identify the relevant acts of the party who is said to be the agent of the charterer, and then determine if that act was in performance of a relevant obligation under the charter, checking, in each case, the wording of the charter party. Any other cause preventing the full working of the ship? Now, the legal use of the word any does not mean what its normal everyday use in English would suggest. In other words, it doesn't necessarily mean all. Instead, where the phrase any other cause is not amended by the addition of whatsoever, then its application is limited by what is known as the justem generis rule. This means that the cause referred to must be of the same type as the named causes which precede it. So although on the face of it, the wording seems very wide, in practice, the scope is actually quite limited, and it means that the following causes only will fall within the scope of any other cause. So in other words, it must refer to the manning or provision of the vessel, serious incidents of breakdown or serious accidental damage to the cargo, or necessary dry docking. It's worth noting also that the courts have drawn a distinction between internal and external causes, and the current position is that only internal causes can fall within the scope of any other cause. So, for example, it does not, the general wording does not cover interference by outside authorities like port state control if they do not relate to the condition of the ship or cargo, unless, of course, there is a specific clause dealing with that to the contrary. What if the clause says any other cause whatsoever? Now, if it says whatsoever, the justem generis rule is disapplied. However, the full working of the ship must still have been prevented. So whatever is covered must still entail a loss of use of the ship against the will of the charterers. And case law has actually held that this phrase can cover an arrest of ship by cargo interests. So it is wider than the previous version that does not include the word whatsoever. What if the charters are responsible for the event in question? Can the charterers legitimately place a vessel off hire where the off-hire event arises from their own breach of contract? Well, the short answer is no. So, although we have seen from our two general principles that standard off-hire clauses operate independently of a breach of charter by the owners, it's long been assumed, but not expressly decided, that a charterer cannot rely on an event which would otherwise trigger an off-hire clause if that event was caused by his own breach of contract. Sometimes the events that prevent the full working of the vessel caused by the charterers or by something or someone for which they're responsible are expressly excluded in the off-hire clause, as we've seen in the cases which we've just discussed. However, there are incidents where such an event is not expressly provided for, but it would seem that even in such cases, the vessel will still not go off hire. And I've just mentioned a couple of cases there. The Laconian Confidence is one where Mr. Justice Ricks discussed a hypothetical case where contraband was found on board the vessel and the charterers were responsible for putting it there. He thought if the charterers were responsible, it would seem absurd to hold the vessel off hire. That may not square with the construction, seeing as the detention by authorities would be any other cause whatsoever preventing the full working of the vessel, but it seems there would have to be some sort of implicit exclusion of causes for which the charterers were responsible. I'm now going to hand you back to Henry, who will deal with the legal effects of the vessel going off hire.
Thank you very much, Pam. Next slide, please. Okay, well, the legal effects. To state the very obvious, the charterers don't have to pay hire for the period in question. In practical terms, though, since hire is paid in advance, this generally means that a deduction will be made from the next or any subsequent hire payment. But charterers have to tread very carefully here. If the vessel is off hire and charterers make a reasonable assessment in good faith of the amount of the deduction, then they're not in breach of the obligation to pay hire in full, and therefore owners can't exercise a right to withdraw the ship from service, even if ultimately charterers' assessment of the amount of off-hire turns out to be wrong. But charterers have no defence if they reasonably and genuinely believe the vessel to be off-hire and so deduct from hire, but in fact they get it wrong and she was on hire. In such circumstances, depending on the terms of the fixture, owners could be entitled to suspend service or even withdraw the vessel from the charter party. The next point on the slide is that in simple terms, deductions can't be made for future or anticipated off-hire. Straightforward. Another key issue to consider is who pays for bunkers while the vessel is off-hire. Well, the starting point here is that where hire isn't payable due to the operation of an off-hire clause, that doesn't affect charterers' other obligations under the charter party unless the charter expressly says so. So unless the charter provides otherwise, the charterers remain responsible for providing and paying for bunkers whilst the ship is off hire. And clause 20 of the 1946 NYPE form is an example of such a clause. It expressly relieves the charterers from liability to pay for bunkers consumed whilst the ship is off hire. But there's no equivalent provision in the wartime form, so charterers using that form should ensure, if they can, commercially, that the words "while on hire" are inserted at the very beginning of clause 4, which deals with bunkers. Now, another practical question which often arises is whether charterers can extend the charter party period to cover off hire. And in short, again, this depends on the wording of the charter party itself. Time charters entered into for long periods of time often contain rider clauses which give the charterers the option to add any off-hire period to the overall charter period. And that right can be really valuable to charterers if the market has risen during the charter party. But charterers have to bear in mind two key points here. Firstly, the mechanism for exercising the option must be strictly complied with, for example, as to when notice must be given. And secondly, once exercised, the option is binding on charterers, so they can't then redeliver the ship earlier if the market subsequently drops. And then finally, the question arises as to whether charterers must pay for any damage to the vessel during off-hire periods. Well, there isn't actually much case law in this area, but the better view is that where payment of hire is suspended under an off-hire clause, that doesn't relieve the charterers of their other obligations. Next slide, please. Damages. Are damages available? Again, this is a key issue that can arise in terms of the legal effects of off-hire. And as Pamela's mentioned earlier, a key thing to remember here is that off-hire clauses are independent of any notion of breach of contract. And off-hire often arises due to an event which has nothing to do with any breach of contract or duty by owners. And because of this, charterers can potentially recover damages in addition to placing the ship off hire, but only if they can establish a loss caused by a breach by owners of some other term of the charter party, and then satisfy the normal rules of remoteness and mitigation. And the quote on the slide is from a judgment in a case called the Democratos and sets this out in the clearest possible terms. If a period of off-hire results from a breach of charter on the part of owners, then the charterers would in law be entitled to damages quite apart from not being liable for hire or being able to recoup any hire paid in respect of this period, if they can establish that they have thereby suffered additional loss. Next slide, please. Okay, final question to consider in the context of a potential claim for damages is whether charterers are entitled to set off, in other words, to deduct such a claim from hire. Now, if there's no express right of deduction, it may still be possible for the charterer to make a deduction from hire by way of what is called equitable set-off. Now, this is a remedy that exists at law in certain circumstances independent from the terms of the contract. And in broad terms, it can arise where the ship owner's breach deprives the charterer of the use of the vessel or prejudices its use of the vessel. And in such circumstances, the charterer may be able to deduct from hire any damages that it reasonably and in good faith believes it to be entitled to. And the actual extent of any damages that the charterer is entitled to will then be determined subsequently. So it's effectively an interim self-help remedy. However, the right to equitable set-off is subject to a number of very important restrictions, and in particular, the courts have held that certain types of claim do not relate sufficiently to the use of the vessel and its prevention or hindrance. And examples include claims for damage to cargo, which I think answers one of the questions which has come through whilst we've been talking, or a master's refusal to load bunkers, or a master's failure to keep accurate logs. For claims of that type, equitable set-off won't be available. So whilst the charterers should always be aware of this potential remedy, they must equally be aware of the potential pitfalls and limitations in terms of using it. If a charterer wrongly exercises a right to set off, there may be very serious consequences, such as the suspension or even the withdrawal of the vessel, depending on the terms of the charter. Well, that concludes the talk that we had prepared, and I'm very grateful, and Pam will be as well, to all of you for your attention. A number of questions, though, have arisen. I've answered one of them just now, but we can turn to a couple of others that have come in. And the first question that we've received is, what is the difference between the full working of the vessel as per NYPE and the efficient working of the vessel as per Shell Time 3 and Shell Time 4? And to answer that, that was actually considered in a case called the Manhattan Prince. And the court concluded that the efficient working of the vessel relates to her physical condition. And therefore, if, for example, the full working of the vessel is prevented by an arrest or a detention, then that will only constitute off-hire if that arrest or detention is the result of the ship's condition or suspected condition. Another question we have had is, do charterers have to pay hire whilst the vessel is off hire? Mrs. Dunning.
Yes, I mean, that's a very good question. So under the NYP 1946 form, It's been suggested that the charterers are not obliged to pay an instalment of hire at all while the vessel is off hire, and there's a case called the Lutetian. But that's only a High Court case, so caution is suggested unless and until a higher court considers this, since a different High Court judge could come to a different decision. He wouldn't be bound by the earlier one. An arbitration tribunal, however, would be bound by that decision. Either way, though, as hire becomes due the moment a vessel comes back on hire, it's another area where you would proceed with caution, particularly where hire is due in advance and the vessel comes back on hire midway through a particular period. Henry, are there other questions?
Yes, another one came through yesterday as follows, and this raises many different points. Where engine trouble occurs and this delays the vessel tendering notice of readiness, can the charterer claim demurrage as well as off-hire? Now, the first point to make here is demurrage is a voyage charter concept. Off-hire is exclusively a time charter concept. So you will not see a charter party that deals both with demurrage and off-hire. And they're similar concepts in some respects. They both deal with lost time. They both operate independently of any notion of breach of contract by owners. But beyond that, they're very different. For example, there's no right of set-off against freight under a voyage charter on an equitable basis, unlike with hire. And also off-hire can be argued at any stage rather than just at or off a load or discharge port, as would be the case with demurrage. But beyond that, in terms of engine trouble, well, that's likely potentially to give rise to a breach of contracts claim for damages, for example, in terms of breach of maintenance obligations or duties under a clause paramount, if the charter party contains one. And it's worth noting in the context of a clause paramount that whilst there isn't a definitive case law on this, the better view is that owners' obligations in terms of seaworthiness and due diligence, and therefore maintenance, would arise at the start of each individual voyage and not just the first voyage under the time charter. So I hope that answers that question. If any other questions spring to mind, then please don't hesitate to get in touch with Pamela or with me, and we'll very gladly answer those. Our next talk then will be on the 20th of May, and that will deal with responsibility for cargo claims under time charters and the inter-club agreement, as you can see on the screen. Beyond that, we'll deal with bills of lading and then speed and consumption. And that will then bring to a close our talks on time charters, which I hope very much indeed you have found useful. Please do give us feedback if you have time to do so, simply so that we can then make sure that these talks are as useful as they can be for you. Thank you very much, and enjoy the rest of your day.